Welcome to On My Way to Wealth, the podcast where busy Gen Xers can learn financial tips as they navigate life on their way to wealth. And now, please join your host, Luis Rosa.
Hello, everyone. Welcome to another episode of On My Way to Wealth. My name is Luis, and I'm your host. Today, I'm speaking with Matthew Winters. He's an attorney with TALG, T-A-L-G. It's a California law firm with offices in Nevada and Dallas. So I'd like to introduce Matthew and let him tell us a little bit about his background and what he does. Welcome, Matthew.
Thanks, Luis. I appreciate you having me on. Like you mentioned, I'm an attorney. I'm a partner here in the Las Vegas office for TALG Law Firm. We practice primarily business law, intellectual property. My personal practice area is tax and estate planning. We also have a family law section as well. And so we usually try and provide all-encompassing service for our clients, whether they're business owners, small personal family members, and everything in between.
Awesome. That is a much needed service. That's one of the reasons why I wanted to have you on, because a lot of my clients have that need in terms of wills and estates and stuff. And there's a lot of miscommunication out there or things that people might not realize that they need. And you're the perfect man for the job. So thank you for being here.
Yeah, thanks.
So let's start off with the simpler matters, and then we can get into more specifics later. But let's say, for example, a lot of people have the misconception that they need to have money in order to have an estate plan in place, whether it's a will, trust, and things of that sort. What do you say to that?
I usually say that's a common misnomer, right? Most people think of the word estate plan and they think, oh, that's for the Rockefellers, for the wealthy people of the world. And unfortunately, that's just not the case. So estate planning, think of everything that you own. You own your home. You have a bank account. You may have a brokerage account. You may have things that you want to protect. A common estate plan is going to protect those things, but is also going to provide some guidance if, in fact, something happens to you. Last I checked, I haven't met anybody that has lived forever. So the reality is we're all going to die at some point. Having the proper estate plan is really going to flesh out who gets what when that time does come.
Gotcha. And going back to what you just said, you say the word protect. Are we talking about like from creditors, or are we talking about more like when you die?
A little bit of both. So known creditors, when you have a trust or a proper estate plan in place, for the most part, you're never going to be judgment proof, but you're going to be able to shield a little bit of your assets away from those people that are coming after your things. And then when you do pass, you maintain a little bit of privacy to where creditors don't know what it is that you have that you're giving to your beneficiaries.
Gotcha. Okay. That makes sense. So let's say, where should one start if we're ready to set something up so that we can designate beneficiaries to what we own and things of that sort? What would be the first step?
So a good jumping off point is obviously contact your financial advisor. They're always going to give you a good starting point as to what kinds of things you have that you need to protect. IRAs and things like that, they already have proper beneficiaries to them, so those might not need to be part of your encompassing estate plan, though they are a consideration. But you really want to make sure that things that I do have, like a house, like a bank account, I want to protect those the right way. So the best place to start most of the time is you want to have a revocable living trust. You want to have proper designees for beneficiaries, powers of attorney and wills and so forth. So it's usually part of an encompassing package.
Okay, got it. So let's get a little bit into the individual things that you've mentioned. So let's say a will, for example. What are some of the things that you can include in a will?
So we all hear the word will and we think of, oh, grandpa gave me everything that he had and this is what it is on this piece of paper. A will is great. It's better than having nothing. It is going to provide a judge in probate court a little bit of guidance, but it doesn't protect any of your stuff while you're alive. It's a little bit of not an ancient, but a outdated form of giving your things to people, but it still gets the job done. And some people, quite frankly, just need a will. So a will just gives a judge guidance when that time does come and you do pass away.
Okay, got it. What about things that are not monetary? Like, for example, say husband and wife, they have children and they want to designate somebody to be the custodian of that person, if God forbid they were to both pass at the same time, or what would be used in that scenario?
Sure. Most states, your will is not going to be enough to provide that guardianship designation. However, it does provide some guidance. So unfortunately, you'll still have, or you won't because you'll be gone, but you'll still have to get somebody to go to guardianship court to have a guardian appointed over your kids. with a trust or with the proper guardianship designations, you kind of cut out that middleman. And so, unfortunately, you're gone, but somebody else now has to raise your children. And so, with the proper trust planning in place, you can give that person some guidance and set up your family for ultimate success after you've passed.
Okay, got it. So in essence, if I hear you correctly, if a couple that has children were to pass, let's say they go on vacation, their 5-year wedding anniversary, they pass, the children then need to get a guardian appointed. And if they don't have an estate plan in place, this will happen via a court process.
Correct.
Got it. So you may not necessarily get the guardian that you necessarily intended to, because that's going to be decided by a judge, I would imagine.
Most of the time, judges try and make family relationships last. However, that's not always the case. Some people don't have uncles, aunts, brothers, and sisters. And so the kids are going to go with the foster family. But that's always case by case scenarios.
Right.
But you really want to provide the judge as much guidance as possible and kind of cut out that middleman of the what if situation.
Right. That makes a lot of sense. Yeah, the more what ifs you can take away from your plan, then the better you'll sleep. That's for sure. So let's move on a little bit to then. Can you tell us just, I know there's probably tons of different types, just what a trust is on a more basic level?
Sure. A trust is basically a contract. So it's a contract between you, your spouse, and the people that you want to inherit things after you've gone. Think of a trust as a different person or a different box. When I'm a little kid, I have my red wagon full of all my stuff. I get to tell people who gets my stuff when I go. So when I'm done playing with my toys, my house, my bank account, those kinds of things, who do I want to take the things that are in my red wagon? It's going to go off to the next person, whoever it is that I give it to. A trust is that vehicle that you delineate through your contract of who gets what.
Okay, got it. And are the trusts then their own different entities, like a corporation where you have to file a separate tax return or anything like that?
Sometimes. So your basic revocable living trust that you would put your home and your bank account in, those are just as you would be able to go use those today. Not a big deal, no annual filings, no tax returns, no nothing like that. But when you get into a little more complex estate planning, when you're looking at irrevocable trusts or asset protection trusts or charitable trust, that's when you start to have those tax filings and you start to have a lot more complexities. Most estate planning attorneys are familiar with those kinds of things. Our office, we handle those all the time. So always consult a professional that knows what they're doing and why it is that they're putting you in those different trust vehicles.
Got it. So the word revocable, does that mean its literal term where basically you can change your mind later and take those things right back out?
You betcha. While you're alive with a revocable living trust, you can change it as many times as you want to. You can change the name. Now, I wouldn't recommend doing that all the time, but you can change the assets in the trust so you can buy and sell your home as many times as you want to. You can change beneficiaries. You can change trustees. You can literally say, I don't want this trust to happen anymore, and revoke it.
Got it.
Now, most of the time, people revoke their trust when they're going through a divorce or through something else, but we have that ability. Through other trust options, you don't necessarily have that ability to go and take all that money out and use it as quickly. So there's always ramifications for some of that. But again, consult somebody that knows what they're doing, and they'll
Got
walk
it.
you through those steps.
Okay, and who are the typical parties to a trust? I know you have yourself. Since you're setting it up, you're considered what, the owner of that trust?
Yeah, when you set up your trust, you are the grantor or the trustee. People call them different things. They really are one and the same. But you're also the trustor. So the trustor is the one that established the trust, right? And then while you're alive, you act as trustee. So essentially, nothing really changes except everything that you do now has to be in the name of the trust. So your home, your bank account, those kinds of things need to be titled in the name of the trust in order to really get the full benefit of what it is that you're doing.
Okay, got it. And then is it possible to have a trustee that is different from the grantor?
You betcha.
Okay.
Yeah. And, essentially name anybody you'd like as the trustee. Now, keep in mind, they're the ones that have the power to do things for your life. But there's corporate trustees, there's attorneys that act as trustees. It's really not that big of a deal. Just make sure you have a little bit of oversight if you are alive and somebody else is acting as a trustee, so where you can see that they're doing the kinds of things that are in your best interest.
Got it. Okay. So in essence, let's say going back to the scenario with the couple with the children, so they can set up a trust, designate a guardian in that trust for their kids, and that person could be named as a trustee?
You betcha.
Okay, got it. And then what if you wanted, for some reason, just additional oversight on that particular person? Can you have like another party who, let's say you had a life insurance policy and you want the guardian to live with the children, but then you want somebody else to kind of like oversee the money. Is that possible?
Yep, you could do that. You don't have to name the guardian as trustee. You could name somebody else as trustee.
Okay.
You could name the guardian as just the guardian. You could have what's called a trust advisor or a trust protector, meaning that person's whole job is to make sure the trust is doing what it's supposed to be doing. So there's a lot of cool things you can do with a trust where you can be very, very creative as to what happens, not only while you're alive, but when you pass with your stuff.
Got it. So that's what they call the hen from the grave?
That's right. Now, we're never going to be able to rule from the grave. Judges will not allow for that. However, we can be pretty discretionary with some incentives that we want people to follow in order to get the money that you have set aside for them.
Gotcha. Okay, cool. Thank you. So let's talk about the other things you mentioned. One of the things being a power of attorney. How do we incorporate that into an estate plan?
So when you sit down and you start to discuss your estate plan with an attorney, one of the things that's always going to come up is powers of attorney form for both financial, healthcare decisions, right? Financial decisions, meaning the day that you sign this power of attorney form, whoever it is that you've designated that has power of attorney over you can go to the bank, can call up the mortgage company, can talk to the power company, can get that kind of information in case either you are not available to answer it or you just don't want to. You really want to be able to free yourself and have that security knowing that all of your stuff is going to get taken care of. Same with healthcare decisions. With a healthcare power of attorney, I want to take that decision making out of a doctor's hands and into somebody that I know and trust that knows my wishes. And so you're giving all of the powers that you normally have that you can speak for yourself to somebody else that doesn't necessarily have that conflict as a doctor would.
Okay, got it. And then you can include things like what to do if you're, let's say, do not resuscitate, for example, things of that sort.
With healthcare powers of attorneys, you can't be as creative because most of those are statute driven, depending on what state you live in. But for the most part, you can really direct what kind of end-of-life care that you receive in a hospital based on your current state and your final wishes to the person that you've given healthcare power of attorney over you.
Okay, got it. Is that the same as a living will?
Very similar. They are interchangeable names. But healthcare powers of attorney tend to hold a little bit more weight, especially when you wave that in a doctor's face. But again, state specific. Some doctors, they still will not honor those, but those are always different conversations.
Gotcha. Okay, got it. So, you mentioned wills, trusts, living wills, and how important they are to have an estate plan. So I wanted to go a little deeper as far as the, for example, explain, if you can tell us in simpler terms, what probate is.
Sure. Probate is really the court process after you've passed away that a judge gets to decide who gets your stuff. Now, typically, probate is a very public process. If you have a will or if you have nothing, you can, in fact, go online and find, hey, I know Joe Smith died yesterday. I can get online and find out exactly what Joe Smith had. It's not a private practice area, and so it's usually subject to all kinds of screwy things that happen. And with that, you have a lot of people coming out of the woodwork to contest what you had. You also have a lot of attorneys that rack up a significant amount of fees just to push your estate through the court system. And it happens. It's relatively easy, but it's not something that you want to subject your family to if you have the option to avoid it.
Got it. Okay, so if you do proper planning ahead of time, you can have a trust in place where basically it bypasses the probate, or at least the public aspect of it.
Essentially, right. So as you mentioned, if you have a proper revocable living trust and you've got your home and your bank accounts and all of your stuff titled in the name of the trust the way it's supposed to be, the whole job of a trust is to skip probate, is to make sure it's very private. So if everything's in the trust, it usually just goes to that next person. You don't have to go through the probate process. Yes, you pay up front for the trust, but typically it's pennies on the dollar to what you're going to pay or your family's going to pay in probate court.
Gotcha. So then basically you mentioned that you have certain accounts like individual retirement accounts, 401ks, things of that sort that you could already designate a beneficiary to.
Sure.
So for the most part, the things that people would then include in the trust are things that you normally can't designate a beneficiary to, right? Like a car and home and things of that sort.
Right. So IRAs, 401ks, things like that, they already have named beneficiaries on them. They also have some taxable consequences where you may or may not want to put that in a trust depending on what your goals are. So again, contact somebody that knows what they're doing and they'll be able to walk you through those steps. However, things like your brokerage account or your bank account at your local bank or the deed for your home, those things need to belong to a trust because they do have title on those that you would otherwise have to go through probate if it wasn't in the trust. Now, things like cars, unless you've got a vintage car, a vintage Rolls Royce or something cool that you want to keep
Yeah, I got one of
and
those.
keep in your family forever, right? I'm not going to put that in a trust, but that's for a different reason. Not so much for the probate avoidance, but more so for the asset protection, right? If I'm out driving my car and I hit and kill somebody and that car belongs to the trust, well, you bet some plaintiff attorneys are going to come after everything in my trust. So maybe I don't want to put that in there.
Gotcha.
Maybe I'll keep that under my insurance. That'll be in my own name. And in most states, it's usually pretty easy to go down to the DMV after somebody's passed with the death certificate and say, I'd like a new title, please.
Gotcha. That's a good point. Yeah. So you're protecting the stuff while you're alive as well. So it's not just when you die.
Sure.
That is awesome. So let's say a couple is ready to get this going. So the first step is meet with an advisor, and then that advisor would typically coordinate with an estate planning attorney?
Some advisors do, some don't.
Okay.
So you really have to be knowledgeable as to what your advisor can provide and what they can. But most estate attorneys do have financial advisors in their network. And so if you don't know a financial advisor, they can set you up with one and vice versa. But that is always the first step, is sit down with your spouse, start to have that conversation. Hey, what would happen if both of us passed? Or what would happen when one of us passes? How do we protect this stuff now, even if we're both healthy?
Right.
Because the inevitable does happen to everybody.
Yeah.
It's just a matter of when.
That's true. And you don't want to leave a beneficiary of yours, they're already dealing with your death, to then have to deal with all this crazy money stuff at the same time. Maybe not the greatest time to start making decisions.
No, and I've seen it from all angles. I've seen it from, hey, we've had a plan and it worked exactly as we thought it would, to, oh, we didn't have any plan and it's going straight to probate court and we've got family members fighting from every single angle.
Right.
And so I can tell you that most of the time when you have a plan, it's usually honored, especially when everything is funded correctly. It's pretty straightforward. It's when none of the stuff is funded or when you don't even know what you had. That's when it starts to get a little hairy.
Got it. Okay. And speaking of funding, great segue. How do you go about, let's say you did set up a trust, and how do you then turn your existing things like your car, your home, et cetera, and make sure that they are in fact funded right into that trust?
So that's kind of a loaded question. And as an attorney, I'm going to give you a weird maybe answer. It depends, right? So depending on what kind of institutions you have, bank accounts, those kinds of things, each institution has its own set procedural rules as to how to get your stuff out of your name and into your trust name. Same with your state. Depending on what state you live in, if you own your home, they're going to have different rules and different guidelines for putting your deed into that trust. So again, consult a professional that walk you through those steps. Again, we do this every single day. So it's one of those things that most professionals are well versed in, and it's a relatively easy process.
Okay. Yeah, that was going to be my next question. So it's that expected that you will have that hand holding, if you would?
Sure. And if you don't get that hand holding, maybe go somewhere else.
Got it. Okay. Yeah, because that sounds super complicated. I mean, I've tried to get a new title for a car. I could only imagine like retitling homes.
Yeah, retitling homes, it should be easy. It should be a relatively easy process. You create a new deed and you put that deed in the trust. Easy enough. Again, some states are different. Some states require you to jump through some hoops. But proper trust funding is something that needs to be done, or else this trust is worth the piece of paper it's written on.
Got it.
So you do need to go through those steps.
Yeah, I say the same thing with financial plans. I mean, the financial plan, if it just sits there collecting dust, then might as well not have happened. You have to take the action steps afterwards. So let me ask you this. So let's say, I know circumstances change. So like, how often should you review these trust documents? Because I'm sure, people get married, divorced, they buy new cars, new homes, et cetera. Kids come into play that they didn't have, new grandkids, right?
You went through about half the situations that you really need to get into. But anytime you have a life change, anytime you have a new child, you get divorced, you get married, you get remarried. Anytime you have any of that stuff come up, you need to review and possibly amend your trust. And again, I know here in Nevada, our trust code changes at least every 2 to 4 years. Every time a law changes, your attorney should be advising you, hey, the law changed. Let's take a look at this. With the new TCJA, the Tax Cuts and Jobs Act, that changed a lot of people's estate plans. And so a lot of things that people had in place, whether it was an original revocable trust or whether they had some more complex trust, a lot of those things changed. And so a lot of attorneys had to make those comfortable or uncomfortable phone calls. Hey, we need to change your estate plan based on the tax code change because it doesn't really affect you the way that we thought it was going to anymore.
Got it. Okay, so this is not a one and done thing.
No, it should be an ongoing holistic planning approach. And that's really what you want to look at your estate plan as, because if it's a one and done, you're probably going to pass soon. Or you better hope that.
Right.
If it's ongoing planning, your life changes, you change jobs. You might change your financial situation. You might inherit a bunch of money from a relative. Well, now how does this affect my estate plan?
Gotcha.
If I inherit an IRA from somebody, that changes your estate plan too. So there's all kinds of variables that go into that, but having that ongoing planning conversation usually helps solve those problems. Again, everybody has different variables. So talk to somebody that knows what they're doing.
Gotcha. Yeah, I feel the same way in terms of financial planning. Obviously, you can't just have one plan and, hey, see you later. Congratulations. Sure. Things change all the time. Tax laws, even if your own life doesn't change, things might just change for you, right?
That's right.
So I wanted to ask you in terms of, let's say, and obviously I know this is different for everybody, but is this like a super expensive thing for people to get done?
Typically, no. Typically, revocable living trust packages, they're usually about 1/3 to 1/10 of the cost of an average probate estate to go through the court system. But the difference is you're paying up front instead of paying after you've already passed. But most trusts are not that expensive. It really depends on what state you live in, what city you live in, what kind of attorney you're working with. But again, most people are also flexible with you too. But I definitely would try and refrain from doing a trust or any kind of estate planning document yourself. There's a lot of really cool, helpful tools out there on the internet, but they might not be able to answer those complex questions that you personally have. And even if you think your life is not complex, it very well could be. Right. And so you always want to at least sit down and talk to that person and figure out, okay, what kinds of hurdles am I going to run into? And then start to formulate your plan from there.
Gotcha. Yes, and that's something you want to cut corners on. And also, I know you mentioned tax law changes. So I know that would also include like some exemption amounts in terms of taxes. Like I'm from New York, so I remember, I think it was 2010, like a law change where like a much higher limit or it was no limit at that point. Because I remember George Steinbrenner, the owner of the Yankees, they were like, oh man, he happened to pass that particular year.
He did luck out that year.
So is there like an amount where like do people pay taxes on inheritance, or is there like a limit, or how does that work?
Again, that's a weird loaded question, Luis. Thanks for that one. But
don't mean to put you on the spot.
And we kind of skimmed over this a little bit. So most attorneys, they have what's called a Juris Doctorate, a JD, that allows them to become an attorney after they pass the bar. I went a little bit overboard and I nerded out, and I got a second law degree specifically in tax law. And so this is a fun question for me because there's so many variables that are included in this. Each state has different estate tax rules. Nevada is one of those friendly ones where if you die here, you don't pay estate tax, except for the federal rate, which currently, if you're single, is $11.4 million. If you're married, is $22.8 million. So if you die and you have less money than that, well, your family doesn't pay any estate tax on that or any inheritance tax on that. Now, if you have more than that, don't be discouraged. We can plan around it. So there's all kinds of fun tools available to you.
That's where you come in.
That's where I come in. If you've got $100 or $100 million, we can still help you. It's not a big deal. There's just different avenues we have to go down.
Got it. So in essence, estate planning is not just for the super high net worth people.
No, estate planning is, I've just got married. You need an estate plan. I'm not married and I've got kids. You definitely need an estate plan. You're married, you have kids, you guys own a home, or I have rental homes. That's something we got to talk about too. That's a little bit different.
Oh, yeah.
I wouldn't necessarily put rental homes in my basic trust. Maybe own an LLC or something so we can get some tax benefits, but also you're providing some asset protection. And then I'll own the LLC with my trust maybe. So there's different things that go into everybody's different plan. And if I said one plan is the exact same as somebody else's plan, that'd be an understatement. So every single person's plan is different.
Gotcha.
And that's why those online sites are not necessarily made for everybody.
That makes a lot of sense. Yeah. And I like the fact that it's not just about what happens when you die, because some people might not even care. I've seen people like, oh, whatever, they can figure it out. But it could also help you now protect yourself if you have investment properties or that classic car, et cetera.
That is true. I did have a few clients that said, I do not care, bury me in the desert, we'll figure it out. And I said, nope, you got some other problems while you're alive. Let's figure those out too.
Right.
So again, everybody has different weird situations and different family dynamics. That's always helpful, especially when you're trust planning, to consider, hey, cousin Judy, she doesn't like me too much, and she's going to come after all my money. So we got to start protecting these things and really set people up for success after you've passed, but also while you're alive.
Yeah, because I've seen when people have passed and I see siblings fighting over a house and things of that sort, because there was just no will. And you hear that a lot in the news. You have all these like celebrities passing with no estate plan in place, and they're like,
I think they did that on purpose, right? Didn't Prince not have a will?
I believe Prince's father, yep.
Well, wait, you got $100 million. This would have been an easy fix.
That is insane.
Imagine the amount the probate attorney made on that one.
Wow.
But no, you've got weird dynamics you've got to plan for. And, it's really crucial when you have any kind of money. It could be $1,000. It could be, like I said, $100 million. But when you have family members that are fighting over now found money to them, they don't care. People get very greedy. People change really, really fast. You see people's true colors when there's money on the table. And 9 times out of 10, that money is going to be spent very fast. And so we need to help protect and also shelter some things from happening, but provide some incentives for those people that are inheriting something to not spend all your money the day that they get it. And so there's a lot of really cool and creative things you can do with trust planning to really help set people up for success.
Okay, got it. So I see you mentioned you have some sort of control. So for example, if you have a kid and they're only like 6 years old now, you could state certain terms as far as like when they get certain amounts of money so they don't spend it all at once, like some parameters?
Yeah, typically, if you've got a minor like that, they can't inherit money anyway. It's going to go into an irrevocable trust for that person. Okay. The money will be given to the guardian until they reach a certain age, and then that child will start receiving some things. But yes, you do want to have that supervision, so to speak. You can't rule from the grave, but we can provide guidelines. So we want to provide those guidelines for those kids, so when they do reach the age where they start to be able to recognize that money, it is set aside for them to, go to college, go do something that we want them to do.
Oh, that's awesome, man. Well, thank you so much. This has been super helpful. So as the last thing, what would you recommend would be a good starting point for people out there that just never thought about this stuff? Like, who should they contact? What would be the first step that you would leave them with?
Sure. First step, have that conversation. That's number one. If you haven't ever had that conversation with your spouse, with your family, have that conversation. That always is going to get you off the ground. Then you start to realize, oh, these are the kinds of things that we have that we need to protect, that we need to be worried about, what's on our radar. Once you've kind of developed what that conversation looks like, and it could take an hour, it could take a week. I know with my wife, she's a marriage and family therapist, so it takes a week. So we're going to hash about everything. But you really want to at least have that communication first. Once you have that communication, find an estate planning attorney. Find somebody that does this kind of stuff. If you have a financial advisor that you work with, get in touch with that person. They'll direct you to somebody that they either have worked with in the past or that they can recommend you to. But once you meet with that estate planning attorney, go in there with some questions. Like, what kinds of things do I want to protect? What will a revocable trust do for me? Do I need these other kinds of things in my estate plan, or is it just a revocable trust? So have some questions, be knowledgeable about what you go in there with, and at least have a way to further that conversation so you can ultimately walk away with the knowledge that I've done the kinds of things to set myself up for success, both now and when I pass.
Awesome. This is great, man. And one more last thing. Like, I know that now things have changed with social media. So you see like people have Facebook accounts and all this other stuff. I would imagine that also plays some sort of role now in your estate plan, like your digital assets, if you would. And I know that could be like a whole nother episode perhaps.
That could be a whole other episode. I have to bring one of my intellectual property partners in here for that one. But yes, those are things that technically people fight about. And it's really weird that, I get to control grandpa's Twitter account. You're like, gotcha. Grandpa had a Twitter account. So those are kind of things that are on the periphery right now that people are just now discovering. But most of the time, those individual companies have rules and regulations as to how they give you access and control over those kinds of things.
Gotcha. Okay. Awesome. This was great, Matthew. Thank you so much.
Yeah, anytime.
Quick question for those people that might be in your local area, whether it's Nevada, California, or Dallas, that might want to reach out to you. Where can they find you?
I won't give you a whole bunch of phone numbers because those are never easy to remember, but our website is talglaw.com. Go ahead and take a look at that. Click on whatever you want to. All 5 different phone numbers there. Give us a call. We're more than happy to sit down and help you figure it out.
All right, awesome. And I'll be sure to put that in the show notes as well. So thank you, everybody, for listening. Quick disclaimer, this is not legal advice. This is for educational purposes only. Definitely consult your attorney for your own specific situation before you make any decisions. Thank you, and we'll see you in the next episode.
Thank you for listening to On My Way to Wealth. If you have any questions, we'd love to hear from you. Send Luis an email at luis@onmywaytowealth.com. To read the show notes and the blog, please visit www.onmywaytowealth.com. Luis Rosa is an investment advisor representative of Retirement Wealth Advisors, Inc., an SEC-registered investment advisor. Build a Better Financial Future and Retirement Wealth Advisors are not affiliated. Exposure to ideas and financial vehicles discussed should not be considered investment advice or recommendation to buy or sell any financial vehicle. This information should not be considered tax or legal advice. Individuals should consult with the professionals specializing in the fields of tax, legal, accounting, or investments regarding the applicability of this information for their situation. Past performance is not a guarantee of future results. Investments will fluctuate and when redeemed may be worth more or less than when originally invested.